Hello students, welcome to Bajirao IAS Academy. See, we have very important news articles for today's discussion. So all these articles are very relevant for both prelims and mains exams. See, so we have the first set of very important articles for mains exam, right? So the first article is pending bills, the issue of gubernatorial inaction. See, recently the issue of Tamil Nadu governor enacting or not acting on bills passed by the state legislative assembly is in news. However, this article deals with the constitutional question of governor not giving assent to the bills passed by the state legislative assembly. Okay, so the next important article is the too many benefits of marriage equality. Same-sex marriages have continuously been on the news, and same-sex marriages, legalization of same-sex marriage is being heard by the Supreme Court. So in this context, the article particularly talks about the advantages of legally recognizing the same-sex marriages and how it will uh, lead to a dignified life of people who have fighting for the same-sex marriages, or they do same-sex marriage, right? The third important news article is India China hold frank and in-depth talks. So line of actual control and the continuous engagement of both the forces at the line of actual control, right from the Doklam crisis, Galwan clashes. In this context, there was a meeting recently between Indian side and the Chinese side to talk about the disengagement and de-escalation across the LAC. So this article is about the India-China disengagement across LAC. See, this article is also very important for mains exam. So we also have a set of important articles for prelims. So the first article is malaria said to be a notifiable disease across India, even as cases show a decline. Malaria is one of the most affected um, disease, especially in tribal areas, right? So several, since India is being a tropical country, India is most vulnerable to disease like malaria. So with the infection like malaria, there has been a high mortality rate. So in this context, India has notified malaria as a notifiable disease. So we will also discuss what is a notifiable disease and what will be the possible implications or the benefits of this. And the second article is a nuclear liability clause. See, a Jaitapur nuclear power plant in Maharashtra. So India, in cooperation with the France, planning to set up the largest nuclear power plant in Jaitapur. So therefore, there has been a nuclear liability clause, and we need to understand what is this nuclear liability clause. And the third and last important article, the death of two cheetahs. So recently, India has reintroduced at least 20 cheetahs from Namibia and South Africa into Kuno Palpur National Park, right? So after the reintroduction, at least two cheetahs died. So therefore, in this context, the Madhya Pradesh government requested the center to select the other favorable sites for the relocation of cheetahs so that the cheetahs population can be managed. Okay, so these are all the important and relevant articles. So first look at the first important article for mains examination point of view. So pending bills and issue of gubernatorial inaction. So his name is PDT Acharya. He was the former Secretary General of Lok Sabha, right? So in this article, he has comprehensively discussed what is the constitutional position of governor, whether the constitution provided a governor to withhold his assent to bills passed by the state legislature. So what is exactly required in order to make sure that he gives assent to the bills which may be in the public interest, right? So in this context, we discuss all the important and relevant provisions. See, this editorial is particularly very important for paper 2, GS paper 2, right? So please make sure you carefully listen all these points and also make note of these points if possible. Right. So we all get to know that recently there has been a crisis like a situation going on in Tamil Nadu. Why? Because the state legislative assembly uh, passed a number of bills, and those bills were not given assent by the governor. In fact, the Tamil Nadu State Legislative Assembly also passed a resolution, right? It also passed a resolution and urging President of India to set a timeline. Okay, so when a bill is passed by the State Legislative Assembly, the bill should be given assent within a specific time period, right? So Tamil Nadu State Legislative Assembly passed such a resolution and asking the president to fix a timeline for assent to be given to the bills which are passed by the assembly. So in this case, what happening is Tamil Nadu governor he is not giving assent to the bills. So therefore, the state government has been passed such a resolution because it may be in the public interest. Such a bill may be passed in the public interest, and if governor does not give assent to such bills, they never become laws. Okay, they never become laws. So therefore, in this context, the Tamil Nadu Assembly passed such a resolution. However, it says that, in fact, after not giving assent, after withholding his assent to the bills, the Tamil Nadu governor himself says that where a particular bill passed by the state legislature, if it transgresses the constitutional limits, so there are any bill, any legislative or the executive action should not be ultra vires, should not be unconstitutional. If it is unconstitutional, then the bill will not become an act. So, Tamil Nadu governor says that if a bill passed by the state legislative assembly or the state legislature, if it transgresses the constitutional limits, then it is the responsibility of the governor to not to give his assent. Okay, so if this bill is ultra vires unconstitutional, then it will be the responsibility of the governor that he will not give assent to the bill. Okay, he will not give assent to the bill, he simply withhold the bill with him. So, however, there are several bills which are passed by the state of Tamil Nadu, State Legislative Assembly of Tamil Nadu, which are pending with the governor, which are pending with the governor. The governor has not made any decision. The governor simply withheld his decision. So, in this context, it is important to understand the relevant articles which are mentioned in the Indian Constitution regarding the powers of the governor to withhold the assent to the bills. This article says that if a state legislative assembly passes a resolution and that resolution requesting the president of India to issue directions to the governor, because governor is appointed by president. Therefore, the state legislative assembly of Tamil Nadu passes a resolution and requesting the president to issue a direction to the governor that whatever functions the governor do, they should be in accordance with the Constitution of India. So what Constitution of India says? Constitution of India says that the governor should act on aid and advice of the Council of Ministers in a state. Okay, so this is the constitutional responsibility of the governor. So in this context, the Tamil Nadu State Legislative Assembly passed such a resolution. Okay, so requesting the president to direct the governor to act in accordance with the constitution, right? So this is largely seen as a new constitutional development. Why it is a new constitutional development? It is because earlier, even though the governor withhold or not give his assent to the bills, generally state governments not passing any such resolutions. But on the other hand, if governor is not giving assent to the bills passed by the state legislative assembly, the state legislative assembly itself passing a resolution and requesting the president to direct the governor to act according to the constitutional provisions. So, of course, this is seen as a new constitutional development. This shows the proactive role of the states on the part of federalism. or federal features, right? So in this context, let's try and understand Article 355 of the Indian Constitution. So this article says that it shall be the duty of union. Article 355 says it is the duty of the union government of ensure that the government of every state is carried out in accordance with the provisions of the constitution. Okay, so this is article 355 says it is the responsibility of the union government to ensure that the governance or the government in every state is carried out in accordance with the constitutional provisions. Okay, but in the case of Tamil Nadu, the government is not carried in accordance with the constitutional provisions, because the governor, he should act on aid and advice of the council of ministers, is not giving assent to the bills. So therefore it amounts to the violation of article 355 of the constitution. So this is what the author has been saying, right? So the article meant to provide a justification for the central intervention in the states. So article 355 says it justifies the central interventions in the state in case of a failure in the constitutional machinery in the state government, right? Failure in the constitutional machinery in the state. So what is the failure in the constitutional machinery in the state means? For example, if a bill passed by state legislative assembly that endangers the position of the high court, then that also amounts to the failure of the constitutional machinery in the state, right? So therefore article 355, the objective of this article is to justify the central intervention in the state. However, the scope of Article 355 needs to be widened. So why it needs to be widened? Even if the governor is not acting upon the advice of the Council of Ministers, then also Article 355 should be invoked, because it amounts to the violation of the constitution and failure of the constitutional machinery in the state, because the constitution itself requires the governor to act. When a bill is passed by the state legislative assembly, the governor himself required to give his assent to the bill as per the constitution. And when the bill is presented, so article 3, article 200, please remember article 355 and article 300, article 200. So what article 200 says? When a bill is passed in the state legislative assembly and it is presented to the governor is mandated to give his assent to the bill, or the governor is required to give his assent to the bill. But in this case, the governor is withholding his assent, not making any decision on the bill. So therefore, it is also a violation of Article 200. And since it is a violation of Article 200, the scope of Article 355 should also be widened, and the governor's inaction should also be covered under Article 355 of the Constitution. Because if the governor does not act in accordance with the constitution and sits on the bills indefinitely, if governor not deciding on the bills which are passed by the state legislative assembly, and he's not making any decision, then he effectively creating a situation where the governance of the state cannot be carried out in accordance with the constitution provisions. So we already discussed that how governor has been violating article 355 and how that amounts to the failure of the constitutional machinery in the state, or the government is not carried in accordance with the constitutional provisions. So therefore this article should also be included under the, because the governor's inaction should also be considered as the violation or the failure of the constitutional machinery in the state. Okay, so if such a situation arises, it is the constitutional duty to invoke article 355. What situation? For example, imagine there are several bills passed by the state legislative assembly. Okay, state legislative assembly, and governor has not been taking any decision on those bills, and they are pending with the governor, and he is just withholding assent to the several bills. So in this situation also Article 355 should be invoked by the center, because the governor is not acting as per the constitutional provisions. And this is what this article has been saying. So however, a resolution which recently passed by the Tamil Nadu government, Tamil Nadu State Legislative Assembly, can be considered as legitimate action. Right? It can be considered as a legitimate action because it is, the government is not carried out in accordance with the constitution. So therefore, the Legislative Assembly of Tamil Nadu has taken up the responsibility and reminded the president that there should be a timeline on the bills passed by the state legislative assembly. So earlier we have discussed Article 200, right? So what Article 200 says? Article 200 says if a bill is passed by the state legislative assembly, then that bill must be given assent by the governor. Okay, governor must give his assent to the bill. However, there are some exceptions to this. There are some exceptions to this because along with giving assent to the bill, the governor also have other similar options before him. When a bill is passed by the state legislative assembly and the bill is presented to the governor have the following options before him, right? So when a bill is presented to him being passed, the bill have the following options before him. Right? The governor will have the following options as per Article 200. So what are those options? First, he may give his assent to the bill. When bill is presented to the governor, after it is passed by assembly, he may give his assent to the bill. And the second option he have is a withhold his assent to the bill. This is the second option, and this is what has been happening in the case of Tamil Nadu. The governor just withholding his assent and not taking any decision indefinitely, right? So he withhold his assent to the bill as well. And the third option available for the governor is send the bill back to the state legislature for reconsideration. Okay, so this is the third option. The governor can also send this bill to the state legislature for the reconsideration, or reserve or send this bill to the president for his consideration. Okay, so in few cases also the governor can reserve the bill for the consideration of the president. Okay, so what are those aspects? For example, if it is if it violates the constitutional provisions. Okay, if it violates the constitutional provisions, if it endangers, the position of the high court, so in that particular cases the governor can reserve the bill or send the bill for the consideration of president. However, the in the case when we have discussed a few options before the governor, when a bill is passed by state legislative assembly and sent to the governor. However, when a governor send the bill for the reconsideration of the house or the state legislature again, if the state legislature passes the bill, the state legislature passes the bill with or without amendments, or taking into the suggestions given by the governor or not taking into the suggestions given by the governor, passes the bill and presents the bill before the governor for his assent, the governor must give his assent to the bill. He cannot withhold his assent to the bill, he must give his assent to the bill. So this is what this article has been saying. However, there has been a significant violation of various constitutional provisions because the governor not acting uh, as per the constitutional provisions, and it also leads to the uh, it also amounts to the government which is not carried out in accordance with the constitution under Article 355 of the constitution. So therefore it is a very interesting case of violation of the constitutional provisions, because constitution gives certain options to the governor. So what are the options? We have discussed earlier. The options which are given to the governor are discussed earlier. However, he should be required to exercise such options, whether withholding his assent, giving his assent to the bills, or reserving the bill for the consideration of the president. He must required to exercise such options which are given by the constitution to the governor. However, sitting on the bill passed by the state legislative assembly is not an option given by the constitution. Constitution has not given the option to just sit on the bill. Sitting on the bill means not taking any decision on the bills. Okay, not taking any decisions on the bill for the inadequate period of time, right? So not making any decision, or not withholding or giving assent or reserving the bill, or sending the bill for the reconsideration of the house. This just sitting on the bill passed by the assembly is not an option given by the constitution. However, the governor doing this is against the constitutional direction. Okay, so this is a clear violation of the constitutional provisions, because the constitution nowhere mentioned that the governor should take indecision on a particular bill passed by the state legislative assembly. So in this context, there is a need for judicial pronouncement. Okay, so since there is no clarity and the governor is also acting in an arbitrary way, there is a need for a judicial pronouncement. Okay, judicial pronouncement either from the Supreme Court or the High Court on this matter, and that will effectively eliminate the existing confusion. Okay, that will effectively lead to existing confusion, and will also pave the way for passing of the bill within a specific timeline. Okay, however, one question that is very crucial to understand is whether Article 200 of the Constitution, Article 200 says when a bill is passed by the state legislative assembly, then the governor must give his assent to the bill. The question which should be understood as per Article 200 is whether the governor can withhold his assent to a bill in exercise of discretionary powers. See, governor enjoys certain discretionary powers. Okay, so he have a certain discretionary powers. But the question under Article 200 is whether the governor can enjoy such discretionary powers, or whether he can do only the advice of Council of Ministers. Okay, so whether on the basis of the advice of the Council of Ministers he can withhold his assent, or with on his own discretion he can withhold his assent. This is the larger question which we need to address. And secondly, Article 154 of the Constitution. So this provision governs the governor appointment and functioning roles, responsibilities of the governors. So under Article 154 of the Constitution, so this article says that governor can exercise his executive powers only on the advice of Council of Ministers. Okay, so Article 154 says governor can exercise his executive powers. Governor have certain executive powers, right? So governor can exercise such executive powers with the advice of the Council of Ministers. Okay, so please also remember Article 154 in this context. So this article says the same. However, along with that, there is another view. Okay, there is another view that a governor can withhold his assent to the bill only on ministerial advice. So few legal experts or legal luminaries, they are saying that the governor can withhold his assent only with the ministerial advice, not with his own discretion, but only with the ministerial advice. However, some other experts ask why a council of ministers generally suggest a governor to withhold his assent to the bill, because that bill is passed by the state legislative assembly. Then why the council of ministers would advise the governor to withhold his assent to the bill? Well, there are several reasons, because the reasons include if the government did not want to proceed with the bill, then it could withdraw at any stage of consideration. While passing a bill, it could withdraw at any stage of passing. And secondly, if the government wanted to repeal it after it becomes an act, it could have a house can repeal the bill as well. Okay, so but why the Council of Ministers advised the governor to withdraw his assent or withhold his assent to the bill, because there are some reasons for the same. Okay, so there are some reasons for the same. What are the reasons? Of course, the government can advise the governor to withhold his assent if it has a second thoughts on the bill. For example, if a bill is passed by the assembly, okay, if a bill is passed by the state legislative assembly and it is already sent to the governor for his assent, okay, if it is already sent to the governor for his assent. However, if the state legislature or the government or the council of ministers have any second thoughts on the bill, then the council of ministers can request the governor to withhold his assent. Okay, so withhold his assent. So in this case, it is effectively suggesting that the governor can withhold his assent to the bill only on the advice of council of ministers, but not on his own discretion. Okay, so he cannot act on his own discretion when it comes to withholding the assent to the bills. But one thing we need to understand, why a governor should be allowed to withhold assent when a bill is passed by the assembly. Why a governor should be allowed to withhold an assent? Because it is already passed by the state legislative assembly, and state legislative assembly consists the representatives of the people, and they act in the public interest. Okay, they act in the larger public interest. Okay, so since they are acting in the larger public interest, any legislation which they brought may be in the public interest. Then why the governor is withholding his assent to the bill? Because understand, the bill is brought before the assembly when there is some urgency. Whenever there is an urgency on passing a legislation, then the legislature would bring a bill, right? So that bill would be tabled, and it may be part of the policy of the elected government, right? So this is a part of the policy of the elected government, and this bill will also be brought because of the public urgency. And the government is ultimately responsible for the people, not the governor, but the government, the elected government is responsible for the people. And what authority does the governor, who is just an appointee of the union government? Please also understand, governor is not an elected representative. Okay, he is just an appointee of the union government. He is just an appointee of the union government. Then what authority does the governor have to reject such a bill which is passed by the state legislative assembly and that represent people in a state? And also understand, in a constitutional scheme of things, governor is just a constitutional head, but he does not have any real powers, especially in India. He's just a constitutional head and he has no real powers. How can such a governor veto? Veto means just withholding or not giving his assent to the bill. So how can a governor veto a legislative measure brought by the government and that is already passed by the assembly? However, withholding an assent to the bill effectively means death of the bill. Death of the bill. Because he is not taking any decision of the bill. He is not resending the bill for the reconsideration of the House, or not giving assent to the bills. It effectively means the death of the bill. The bill will not become an act. However, only judiciary can intervene in this matter and set the right course. Okay, set the right way of clear enunciation, enunciation of the law. Okay, enunciation of law. So therefore, the confusion which is existing in this sphere can be cleared by the judiciary, okay, or the judicial intervention. However, before actually understanding what kind of a judicial intervention is required, first understand the issue of justiciability of the existing matter, the governor withholding his assent to the bill. Okay, because it is necessary to look into the question of justiciability of the whole issue of assent by the governor. Okay, so in earlier few cases by the Supreme Court, this is Hosted Pharmaceutical Limited and State of Bihar and others case. Please remember this case also, Hosted Pharmaceuticals Limited and versus State of Bihar and others case in the 1983. So what the Supreme Court says was the power of the governor under the constitution to reserve a bill for the consideration of the president. Okay, so in fact it upheld the power of the governor to reserve the bill for the consideration of the president in this particular case. Okay, the court also held that governor reserves a bill for the consideration of the president in exercise of his own discretion, not on the basis of the recommendation of the council of ministers, but he acts on his own discretion. So the Supreme Court given or upheld the discretionary power of the president in the case of reserving the bills for the reconsideration of the president. Okay. However, the court also says that it cannot go into the question of whether it is necessary for the governor to reserve the bill for the consideration of the president. So all these details, court did not go into these details whether it is necessary or not, because constitutionally also president enjoys certain discretionary powers. Okay, the president enjoys certain discretionary powers, so therefore the court does not go into the details of whether it is necessary to reserve the bill for the consideration of the president. And this case too does not deal with the justiciability of assent. Okay, so this case also with the pending bills or the withholding assent to the bills does not deal with the justiciability of the assent. However, it says that the issue that is agitating the existing state government, that is Tamil Nadu government or even Telangana government also. Okay, because Telangana governor also withheld assent to several bills. But the larger issue which is concerning or agitating the state government is indecision. Okay, so not making any decisions. He's not using any of the options before him, reserving the bill for the reconsideration of the president, or sending the bill for the reconsideration of the house, giving assent to the bill, or withholding his assent. Indecision on the part of the governor, the bill is already passed by the assembly. This is what the major concern of the majority of the state government. However, what is the exact and actual opinion of the constitutional framers in this respect? The framers of the constitution would never have imagined governors would sit on the bills for an indefinite period or act indefinitely, not making any decision on those bills. Okay, so under Article 200, okay, under Article 200, governors not making any decisions on the those bills, and this new development which needs a new solutions. Okay, the new development is the what is new development? Governors not acting upon the bills, governors not acting upon the bills passed by the state legislative assembly, and this new problem requires, or new development requires, new solutions with a framework within the constitution, and that solution should be within the framework of the constitution, right? So it falls on the Supreme Court to fix a reasonable time frame. So it is the Supreme Court which can fix a reasonable time frame on the part of the governor to give assent to the bills passed by the state legislative assembly, because the state legislative assembly represents the will of the people. Okay, it represents the general will of the people. So therefore the Supreme Court should intervene and fix a reasonable time frame for the governors to take decision, and it is also in the larger interest of the federalism of our country. Okay, this is also in the larger interest of federalism of our country, right? So this is what this article says. See, this article is very important for paper 2. Okay, please revise these points, go through all these points, and also remember the important constitutional provisions which I have already mentioned, right? So the next very important news article is regarding the same sex marriages. Okay, same sex marriages. Supreme Court has been hearing several petitions asking for recognition of or legalization of same sex marriages. In India, same sex marriages are not legalized. Okay, so they are not yet legalized. However, same sex relationships under Art Section 377, Section C 377 were decriminalized by the Supreme Court. In the same spirit, these petitions were also filed in the Supreme Court to decriminalize or to give legal recognition to same-sex marriages. Okay, so in this article specifically talking about the same sex couple and how they are generally deprived of several social benefits from the government side, and how they lack the social recognition also. And if social recognition provided to these same sex couple, they enjoy several tangible and intangible benefits. Okay, they enjoy several tangible and intangible benefits. So in this article, we just try and understand what are those issues which generally same-sex couple face. Okay, so this article says that the Supreme Court started hearing petition from the lesbian, gay. So this is just a, like a abbreviation of LGBTQ plus community. Okay, lesbian, gay, bisexual, transgender, and poor. Okay, so the petition seeking same-sex marriage equality. These petitions are actually filed in the Supreme Court, and they are seeking the same-sex marriages equality and legal recognition to the same-sex marriages. The Supreme Court already started hearing of these petitions. In India, the institution of marriage is of very fundamental importance. It is generally seen as a sacred union. Okay, it is generally seen as a sacred union among the individuals. So therefore, in this context, getting married is one of the highlights of becoming an adult. Okay, getting married in our Indian society is an highlights of becoming adult. In fact, married couple are generally seen as more accepted and respectable than the non-married couple in our traditional culture. See, this article is very important and very relevant, especially for the paper one point of gender studies paper one point of view. In society section, they may ask this question about the same-sex marriages. Okay, same-sex marriages. So therefore, you have to understand all these points very clearly so that you can write a better answer. Understand, the non-married couple in our traditional culture are generally respected and also accepted by the society. However, the society excluding the LGBTQ plus communities. Exclusion means not giving respect or the respectable position, or they lacking acceptance, or not giving the legal recognition to marriages between LGBTQ plus persons. Uh, that leads to depriving of these communities from enjoying benefits. Okay, so that leads to these communities depriving the full benefits of participation in the family and community life. It also excludes them from the acceptance in the society. So therefore, the article has been suggesting that the recognition, acceptance, and the kind of a respect for married couple or the heterosexual couple should also be given to the same sex couple. Okay, that make them enjoy the full benefits of participating in family community life, and it also excludes them from acceptance in society. Okay, so uh, society generally lack acceptance for these homosexual couples. Okay, so same sex couple. So therefore, uh, a kind of a respect or the legal recognition will pave the way for acceptance in the society over a period of time. So, what is a distorted union? What is a distorted union? Distortion of the union, right? Distortion of a union means generally in Indian societies, marriage is considered as a sacred union between a biological man and a biological woman. Okay, biological man and a biological woman. So, when it comes to the same sex marriages, general perception among the people is that it distorts the sacred union of marriage, that is between biological men and biological women. Okay, so they generally believe that it distorts the union, the existing institution of marriage. So, understand the common reason given is that marriage is defined as a union between man and woman only. So, to allow LGBTQ plus persons to marry would somehow distort the existing union between man and woman. So, this is the most common reason generally given by several people. that why they don't allow, why they don't accept the same sex marriages. Okay, so the same sex attraction is a natural part. So it is just a natural part on human society. It is not a crime or illness. It is not a crime or an illness. It is just a natural part, and it is also part of the fundamental rights of the people, or the liberties of the people, or the autonomy, bodily autonomy, right? So it is part of the bodily autonomy of the people. So LGBTQ marriage takes nothing away from those straight couple, the union, the sacred union between biological men and biological men. So uh, it will not harm the couple, the marriage between biological men and the biological woman. Yet it means, but however, recognizing, accepting, respecting marriage between the same sex couple is uh, I mean, it is a big deal for them. Okay, it makes a huge change in the lives of the LGBTQ couples. They are seeking the fundamental right like any other couple, or they seeking equality like any other couple. First, understand marriage benefits of a couple are both tangible and intangible. Right. So, what are the tangible benefits? Tangible benefits are just a material benefits, right? Material benefits. However, intangible benefits are, you can experience them. You can experience them. So these are tangible and intangible benefits. First, let's discuss some tangible benefits which are generally accrued to the same-sex couple if a legal recognition is provided. The tangible benefits include ability to open joint bank accounts. So they can open joint bank accounts. They can jointly buy, rent a property, jointly own share assets, and they can be recognized as a relative under the Indian Income Tax Act, and access to spouse health and life insurance, and inherit spouse assets. For example, there is no legal recognition for same-sex marriage. Okay, no legal recognition for same-sex marriage in India. However, even though there is no legal recognition, two individuals, two individuals have married. Okay, they married, but they are married same-sex marriage. That is same-sex marriage. So in this case, one individual is working, one individual is working. If he died, one individual is died, the pension which generally given to the spouse of this person is denied to the person he is married. Okay, the person he is married, because there is no legal recognition of same sex marriage. Not just pension, but also adoption is prohibited. Adoption is prohibited or not allowed among the same sex couple. So they will have a several tangible benefits if legal recognition is provided to the same sex marriage. Okay, so these are the essential protections with most heterosexual couple are biological men, less biological woman. So these are all the benefits are enjoyed by the heterosexual couple, but they are denied to the homosexual or LGBTQ plus community. So therefore, they are demanding equality of both heterosexual couple and the homosexual couple on the so that they can enjoy four tangible and intangible benefits. Okay, so let's also look at some intangible benefits. We have understood what are the tangible benefits, and also look at the intangible benefits. So they gain legitimacy, they also gain respect, affection from the society. Okay, so they can also participate fully in their family events. The family recognizes, the society respects them, the same sex couple. These are some of the intangible benefits. Okay, so in fact, the marriage equality enhances the family bonds and encourage unity among the people of same sex couple. So these are some of the intangible and tangible benefits generally given to the people, or generally accrued to the people if their marriages are recognized legally. Okay, so along with that, what is the situation of this LGBTQ uh, people who are working in the private companies? How it has been impacting the work culture? How it has been impacting the work culture? And what are the measures these corporates have been taking to create a more sensitive environment, a sensitization of employees, create of fairness, equality, and non-discrimination, especially keeping in mind the LGBTQ plus communities. First, understand the efforts to improve diversity and inclusion in the Indian workplace. Indian workplace is just workplace like corporate houses, government houses, etc. So the workplace have gathered momentum in the recent past. Okay, so many corporations have applied the core human resources principles. What are the core human resources principles? Fairness, equality, and non-discrimination to these LGBTQ plus employees. Okay, and they have also rewritten their equal opportunity. Okay, so whatever policies they already have, they have rewritten so that they are more suitable for the LGBTQ plus communities and create a more conducive working environment for LGBTQ communities, following the principles of fairness, equality, and non-discrimination. Okay, so along with these, uh, the companies or the corporations have been taking proactive steps or the measures or rewriting their policies in order to prevent discrimination, bullying, and harassment of LGBTQ communities, protect from these evils or these things. The corporations have been taking several proactive measures. So some companies extend several such benefits. The benefits like health insurance to same-sex partners, their employees. However, these policies have been challenging to implement. Because why challenging to implement? Since legal recognition has not been given, they were denied several tangible benefits. That includes insurance also. Insurance companies generally don't recognize same-sex couple. Okay, they don't recognize same-sex couple as a married couple and spouse. So therefore, they have been still facing several problems or the challenges in implementing these tangible benefits to LGBTQ communities. These inclusive and fair policies have not led to negative consequences or backlash from the majority of the workforce. Okay, so the majority of the workforce has not protesting against the measures which the corporations have been taking to create a conducive environment for LGBTQ plus communities. Okay, so inclusive policies which are adopted by these corporations, they encourage a diverse set of workforce and will also result in loyalty and engagement of all the employees, and that will be like a long term asset for the company. Okay, so loyalty and better engagement and the creation of a better work culture would leads to the sustainability of such companies. And it also says that now it is a time of this sense of belonging to be felt home to. Okay, so homosexuals to be recognized with such benefits or to recognized legally that their marriage should be recognized, and belonging to the family and being allowed to marry. So they should also be allowed to marry uh, the same sex couple. Okay, so LGBTQ citizens deserve the right to participate in one's society's major institutions. So generally, they are discriminated, they're bullied, or their harassment is a very common thing for LGBTQ people. So therefore, they have all the right to participate in society's major institution. Along with that, they also deserve to be treated equally with the same-sex couple under the law of this country. So this is what this article has been saying. See, all these points are very important. Please make note of these points. Okay, so along with that, please also try and understand the marital rights same-sex couple do not enjoy. Since same-sex marriage is not recognized in India, these are the rights which are generally denied to the same-sex couple. They are government pensions, medical benefits are not given to the same-sex couple, and claiming leave travel allowance for the partner of same-sex couple is generally denied. Okay, so no property and no inheritance to same-sex couple, and they cannot adopt children also same-sex couple. And in the case of separation, if they are separated, there is no provision to seek maintenance by the economically weaker partner. If these two individuals have separated, one is maybe an economically weaker partner, so he cannot seek any provision for maintenance. He cannot seek maintenance. So therefore, this is also a hurdle. So right to take emergency medical decision, they cannot also take emergency medical decisions. So these are all the problems or the challenges the same-sex couple have been facing. So therefore, they are demanding legal recognition to the same-sex marriages, and also understand why they are fighting to recognize the same-sex marriages. What are their arguments? Okay, so we already know Supreme Court started hearing the petitions, a batch of petitions that seeking legal recognition to the same-sex marriage. Okay, so what are the people of same-sex marriage they generally arguing? They're arguing that the sexual orientation is an essential component of individual's identity and dignity, which are embedded in the right to life of Article 21 of the Indian Constitution. This is their most common argument. The second argument is a decision to marry or not to marry is one's life's momentous or self decision, right? So it should be one's momentous act of self decision. And third, law protects and recognizes the companionship through the institution of marriage. So, through the institution of marriage, law protects and recognizes the companionship through the institution of marriage. And the fourth argument they put forward is sexual autonomy and freedom to choose one's partner is an intrinsic part in the selfhood, in the sense of selfhood. So, these are all the arguments they are putting forward in order to recognize the same sex marriages. Okay, so along with that, we have a very important news article for this is very important for mains. You may get the question about line of actual control, and India China relations with respect to a recent dispute standoff at the LAC, recent standoff at the LAC, right from the Doklam crisis to the Galwan crisis, right? Galwan clashes. So, in this context, let's try and understand what is a line of actual control. See, recently the 18th round of talks between senior military commanders was held. So, in order to disengage and de-escalate the troops on both the sides, the military commander level talks of India and China will take place regularly. Okay, so that they can normalize or they can bring normalcy at the LAC, and that will further increase the bilateral relationship between these two countries. And it is held and the Chinese side of the Chushul Moldo border. Okay, on the Chinese side here, the military commander level talks, and that is Chushul and Moldo is a meeting point. And this is particularly relevant or the important because Chinese defense minister said to visit India, right? So Chinese defense minister visit India, and both sides agreed to maintain peace along the border areas, and that would enable the progression of ties between India and China. This is what this article says. And first, try and understand what is line of actual control, right? This is actually the line of actual control. You can see here, this is the Indian Aksai Chin region, but it is now controlled by uh, China, right? So this is Galwan Valley. Please also mark these areas: Galwan Valley, Pangong So Lake, and patrol points. This is Karakoram Pass. This is all the LOC region that is now controlled by China. Sorry, LAC, line of actual control. Okay, so majority of the border clashes are took place across the line of actual control between India and China, right? So you can just remember all these factors because UPSC earlier also asked a question about uh, location of Leh, Nubra Valley, and Siachen Glacier. So UPSC asked which of the following is the northernmost. So therefore, it is very important to just remember all these factors. Okay. So first, also understand the timeline of the clash between India and China. Okay. So on May 5th, India and Chinese soldiers clashed at Pangong So Lake. The first clash was at the Pangong So Lake. This was actually in the year 2020 took place, and May 10th face off at the Mogotang Valley in Sikkim. And May 21st, Chinese troops enter into the Galwan River Valley. Galwan River Valley is on the Indian side. Here you can see the Galwan River Valley in the Ladakh region. And Chinese camps at three places, hot springs P14 and P15, and followed by the violent face off. So there were casualties also on Indian side and the Chinese side as well. So this is actually the timeline and the location of the Galwan Valley, Aksai Chin, and line of actual control between India and China. So now let's try and understand the article which is given in this newspaper, right? So India and China have Sunday held a frank and in-depth talks on two remaining friction points. So there are two remaining friction points only, and India and China held frank and in-depth talks over the friction points are the points where the disengagement has not yet takes place. The troops are heavily deployed in these regions. Okay, so both countries have a significant disagreement. Okay, so therefore that areas are called as friction points of the line of actual control, and this is especially the frank and in-depth talks between India and China is especially ahead of the first visit of Chinese defense minister to New Delhi. The Chinese defense minister to visit New Delhi uh, in coming days, so therefore it has taken place before his visit. However, since the start of the border crisis, the restoring of the peace along the border areas would enable progress. No doubt that India-China relations have strained in recent past because of several reasons. First is the Doklam crisis, and then the Galwan clashes. And the Galwan clashes, apart from the Galwan clashes, frequent incursions by the Chinese forces into the Indian state of Arunachal Pradesh. Along with this, China has also frequently issuing names for several regions in Arunachal Pradesh. So because of all these factors, there has a strain in the relationship between India and China. However, the border talks or the restoring peace across the border areas would enable progress in these recently strained talks. The 18th level round of border talks between senior military commanders. So since the rounds of talks started in the April 2020. Okay, so when the LAC crisis was started, since then the senior military commanders of both these countries regularly or frequently holding such talks. It is primarily triggered by Chinese multiple transgressions and mobilization of troops into the Indian side. Okay, the two sides had a frank and in-depth discussion on the resolution of the relevant issues across the LAC. So both sides in the 18th round of talks have discussed all the relevant issues in the western sector. Okay, so there's a western sector. In the western sector they have discussed all these issues, and the primary focus of these talks is restoration of peace and tranquility at the border areas, right? So restoration of peace, tranquility, normalcy, and withdrawal of forces from the both China and India, and that would further led to the improvement in the bilateral relationship between these two countries. Even though so far 18 round of talks were held between senior military commanders, there was no significant breakthrough at. So there are two remaining friction points. So all the areas have been disengaged so far except the two friction points. So one friction point is Demchuk and the other friction point is Depsang. So these are the areas these two countries still disagree, okay, to disengage forces. So except these two areas, all the friction points have been brought back to the normalcy. Okay, right. Both sides disengaged in four other areas along line of actual control. So they have already disengaged in four other areas across the LAC, but not from Demchong and Depsab. So they also set the buffer area. Okay, so this is a buffer area, and each forces should not reach this buffer area. Okay, so this is like an area which maintains peace, and this is a buffer area. However, India has so far maintained that the disengagement and de-escalation along LAC, which has seen a tens of thousands of forces deployment and deployed in forward areas, are both critical for restoring ties. So India's traditional position is that India generally link the bilateral relations with China with the border, okay, the border disputes. However, what China generally suggests that uh, India should not link bilateral ties with border issues. So this is the major difference. And India generally very often says that restoring normalcy and peace is very critical for restoring ties with China, right? So this is actually the India's position. And also understand Relationship or the relations have since 2020 have been in the state of freeze. However, relationship between India and China are in the state of freeze. The bilateral trade figures in the year 21-22 and increasing India's imports of Chinese goods reaching a record highs. Even though the bilateral ties are in a state of freeze, the bilateral trade between India and China or imports from China in the years 21 and 22 at a record highs. And also, this is particularly in the context of India this year, 2023, holding the president or assumes the presidency of G20 summit and the Shanghai Cooperation Organization summit. Okay, so in this context, it is very important for because in G20, India and China are members. In Shanghai Cooperation Organization, also India and China are members. So therefore, in this context, it is very critical for these two countries to stabilize a normal maintain the normal ties. However, also understand the investment flows. Okay, so traditionally, a trade between these two countries has boomed in recent past, but India curtailed the flow of investment. India curtailed the flow of investment. See, what happened was during COVID-19 pandemic, there was a lockdown. Okay, pandemic, there was indefinite period of lockdowns across the country. So there is a lower demand, slump in demand, economic growth and economic development. At the time, the company's total valuation, Indian company's total valuation is also very less, very low led to a decline. So therefore, in order to prevent the opportunistic takeover by the Chinese companies of Indian companies, the government of India prevented the investments from China, curtailed investments from China. Okay, so because of this reason, there's no inflow of investment from China, a significant investment from China. However, it is also true that India has not yet given any green light for resuming direct flights. So after the pandemic, India stopped the direct flights to China, not yet given any green signal for resuming the direct flights between these two countries. Okay, they are suspended after the pandemic and they yet to restart. However, the cross-border movement of business people and tourists also reduced in the recent past. So, for the people-to-people ties, the cross-border movement of the people and tourism is also very important and critical. However, India has seen China's mass deployment as leaving status. So, when China deployed a large number of troops into the line of actual control, India generally seen this as a violation of the earlier agreements which are signed in the 1993. Okay, so the agreements were signed to maintain peace uh, and tranquility in the region. So this agreement was signed in the 1993. When China deploys large number of troops in 1990, large number of troops to LAC, India sees this as a violation of the 1993 agreement. However, the border issue remains so complex between these two countries, but it still requires the both to further implement mechanisms at all levels through different channels of communication, not just at the political level, diplomatic level, and commander level talks for the military. So all the levels they should further engage and implement all the existing mechanisms, right? So this will help meet the halfway as much as possible, so that to find a fair and reasonable solution to this problem of frequent clashes between India and Chinese forces, and that will also help improve the ties between these two countries. Okay, so the next very important news article is a nuclear liability issues not yet resolved for Jaitapur project. Okay, the French firm EDF. So in this article, first understand where is Jaitapur located. So Jaitapur nuclear power plant is located in the state of Maharashtra. Okay, so this is located in the state of Maharashtra. Just remember. So even though it is located in the state of Maharashtra, another notable feature of this nuclear power plant is that uh, it is a 9,900 megawatt project, which is the world's biggest nuclear power generation under the consideration at present. Okay, so if it is constructed, it will be the largest nuclear power generation project in the world. So therefore, first understand what is now in order to construct a Jaitapur nuclear power plant, a French-based company or France has been a major supplier. Okay, in this case, France is a major supplier. However, both France and India have disagreement over the nuclear liability. Okay, nuclear liability. So in this context, we should understand what is a nuclear liability. Okay, so what is a nuclear liability? So uh, a nuclear liability is a principle which is provided in the Civil Liability for Nuclear Damage Act 2010. Okay, so this is actually says that several countries have nuclear plants and nuclear operations are liable for any damage caused. See, generally, after the Fukushima disaster in Japan, there has been a growing apprehension of these nuclear reactors because they leave a large scale destruction if any accident takes place. So therefore, India introduced a nuclear liability clause. So nuclear liability clause says that the country's nuclear plant operators are liable, whatever operators of the nuclear plant, right? So nuclear plant operators are liable for any damage caused in the event of an accident. If an accident is caused in a nuclear power plant, in the case of France, right? For example, France is a operator or the supplier. So in the case of an accident, this country is liable for compensation payment against they take out liability insurance. Okay, so they take out the liability insurance. India had been a notable exception because with reactor suppliers potentially liable for damages. So in this case, France is a reactor supplier for Jaitapur nuclear power plant. Now France is also potentially liable for damages in the event of any accident in the nuclear power plant. So therefore there has been a disagreement between India and France over this nuclear liability clause. So the 2010 legislation makes Indian operators primarily liable for nuclear accident, but still keeps open the possibility of recourse to the suppliers. So there will be a recourse or the possible solution for the suppliers as well, right? So understand the civil liability for nuclear damage act. This act is very important. Please remember the civil liability for nuclear damage act. See, this seeks to create a mechanism for compensating victims. So if an accident takes place in a particular area, then there will be victims because of radiation, or they lost their livelihoods, they lost their habitat, housing, etc. So uh, there will be a mechanism for compensating the victims of nuclear damage arising from the nuclear accident or the nuclear incident. So, what are the key features or the key provisions of the nuclear liability for the civil liability for nuclear damage? So, it fixes liability of nuclear damage and specifies the procedures for compensating the victims of nuclear accident. And second provision is that a liability on operators gives them a right to recourse against a certain person. And it caps the liability of the operator. The operator liability is around 500 crore. Okay. So the total liability of an operator is 500 crore. And if a damages exceeds this amount, up to 300 million SDR will be borne by the central government. Even if the damages exceeds above 500 crore, and 300 million SDR will be borne by the center. All operators except the central government need to take insurance. For example, even the foreign companies also, the foreign companies, Russian companies, US companies, France companies, they must take new insurance to provide financial security cover to the liability. Okay, so for facilities owned by the government, the entire liability is 300 million SDR will be borne by the government itself. If a nuclear facility that is owned by the government, then the 300 million SDR will be entirely borne by the government in case of any accident. However, along with that, the bill also specifies the Civil Liability for Nuclear Damages Act also specifies that uh, who can claim compensation, who are the real victims, and who can claim the compensation, and the authorities who will assess and award compensation in case of a nuclear damage. Okay, so this is all about the civil liability for nuclear cooperation, and also the Jaitapur nuclear power project, which India is planning to construct in cooperation with a French firm, EDF. Okay, this is Electricité de France. This is called as EDF, and this will be the largest project under consideration. Okay, so in this context, it is important for us to understand the nuclear power plants in different states, because there is a likelihood that UPSC may ask the nuclear power plants and their location also. So please go through all the nuclear plants in different states, and also remember the state governments also. For example, Rawatpata, Rajasthan; Tarapur is in Maharashtra; Kudankulam, Tamil Nadu; Kakrapara, Gujarat; Kalpakkam, Tamil Nadu; Narora, UP; and Kaiga, Karnataka. Okay, so in the same way, please also remember all these nuclear power plants. And the next very important news article is malaria said to be a notifiable disease across India, even as case show a decline. See, malaria is one of the most serious disease in the context of India. It has been affecting several poor people in the tribal areas, remote rural areas, and hilly areas. There has been higher levels of mortality also because of malaria. There has been higher levels of mortality because of malaria. However, India has set several targets. Okay, the targets are malaria free, making India malaria free by the year 2027, and completely eliminate malaria. India planning to completely eliminate malaria by the year 2030, in line with the Sustainable Development Goals 2030. Okay, so these are the targets India already set. So therefore, despite there has been a reducing number of malaria cases in India, India has designated malaria as a notifiable disease. So what is a notifiable disease means? Notifiable disease means any disease that is required by the law to be reported to the government authorities. For example, in a particular state, there are a total of 50,000 malaria cases. 50,000 malaria cases in 2 months or 3 months. So the legislation, or these cases should be legally reported, and these cases should not be neglected. Okay, so these cases should be legally reported to the government by the healthcare facilities, and this will help collation of information and allows the authorities to monitor the disease, and also provides early warning of possible outbreaks. So see, if we have the information, if we have a data about the particular disease, and that will help take a data driven, data governed decision making. Okay, so that will see, across India, if we have correct information about malaria, then we would be able to take more appropriate action, right? For example, we can identify the potential malaria hotspots, and the actions mainly focus on those areas where there has been a higher levels of malaria, and that will help meet our existing targets, making India malaria free by the year 2027, and also completely eliminating malaria by the year 2023. So along with that, what are the other aspects of notifying a disease? It generally notifies during the pandemics, and it potentially dangerous to human or animal health, also called a reportable disease. Notifiable disease is also called as a reportable disease. Okay, we have understood what is a notifiable disease and why the government wanted to bring it as a notifiable disease. So when it is a notifiable disease, it is a law mandates, a law requires that it should be reported to the government immediately, so that the government will take more appropriate and necessary action. It will also help us in making a data driven decision making, and identify the potential hotspots of malaria. So therefore, there will be a convergence of policies, convergence of schemes could be taken effectively. So along with that, please understand the near real-time data available after the notifying malaria as a notifiable disease, and monitoring it through an integrated health information platform, malaria portal. Okay, so this will be monitored through integrated health information platform, a malaria portal, and this will also help us in periodic regional review meetings and to keep check on malaria growth across the country. So that because of all these measures, we will ensure that we can eliminate malaria. So we can achieve the vision of making India malaria free by the year 2027, and also completely eliminate the disease by the year 2030 in line with the sustainable development goals of 2030. Okay, so this is all about notifying the malaria disease as a notifiable disease. So in this context, first understand malaria is a mosquito borne disease. Okay, so malaria is a mosquito borne infectious disease, and that affects humans and other animals. It affects not just humans but also animals. And it is caused by a single celled, not a multi celled, but single celled microorganism. The microorganism name is Plasmodium group. Please also remember the Plasmodium group. Malaria is caused by the Plasmodium group of microorganism. Right? So this is a protozoa. This is not a virus or bacteria, fungus. This is a protozoa. Okay, so please also remember this, and it is caused by Plasmodium group of microorganism. It is caused by protozoa, and this is actually the cycle of malaria, how malaria spreads from one person to other person. Please remember, an infected mosquito bites a person who becomes infected. For example, there is a person, right? There's a person who is infected, who is already infected with malaria. Okay, so if a mosquito bites this person, if a mosquito bites this person, the spores will enter, the mosquito spores will enter into the mosquito. Okay, now secondly, infected liver. This is the second stage, and first stage, what happens is that uh, if a malaria bites a person, and that lead to that infects liver, and that also infect the red blood cells. In the third stage, it infects the blood cells and infect the blood cells, and also lead to reducing the count of blood cells and the death of mass mortality of the blood cells. Okay, the fourth stage, mosquito bites infected person and becoming infected. So generally in this case, mosquito usually works as a host. Okay, so it is generally a host. It transmits the mosquito virus from one person to the other person. So this is all about designating mosquito as a notifiable disease. So please also understand the next important article, next very important articles. The cheetah introduction program. We already know that cheetahs, at least 20 cheetahs from both 20 cheetahs from both Namibia and South Africa. Namibia and South Africa were introduced into the Kuno Palpur National Park. Okay, Kuno Palpur National Park, which is located in Madhya Pradesh. Okay, so for the UPSC examination point of view, this is very important. So Kuno Palpur National Park, this is located in Madhya Pradesh. So what happened was actually recently, back to back, two cheetahs were died. So that raised concerns of the suitability of the Kuno Palpur National Park to host cheetahs. Cheetahs are generally considered as a vulnerable category because they are African cheetahs. Asiatic cheetahs are critically endangered category of IUCN Red List, but now these are vulnerable categories. Since India planned to conserve these cheetahs, the deaths of these cheetahs is particularly a concern, right? So therefore, the Madhya Pradesh government has requested this center and the National Tiger Conservation Authority to, translocate these tigers to the suitable place so that they can have a higher survivability rate. Okay, they can have a higher survivability rate. So please also understand the other favorable locations for the translocation of tigers would be uh, right a newer the Gandhi Sagar, okay, Gandhi Sagar Wildlife Sanctuary and Naura Dehi Wildlife Sanctuary. See, also remember the Gandhi Sagar Wildlife Sanctuary and Naura Dehi Wildlife Sanctuary both are located in the state of Madhya Pradesh. Okay, so these will be the possible location of translocation of uh, the cheetahs because these two national parks also have a similar a kind of environment like a Kuno Palpur National Park. Okay, um, this is what this article is all about. Um, just remember the Kuno Palpur National Park and the IUCN status of cheetahs, and where they wanted to relocate these cheetahs from the Kuno Palpur National Park, and also understand in this context the few interesting facts about cheetahs. Cheetah is the oldest big cat species, and the ancestors of cheetah can be traced back to about 8.5 million years. Okay, so the ancestors of cheetahs can be traced back to 8.5 million years, and the number of cheetahs as of now is under 7,500 individuals only. Because since they are African cheetahs, their numbers is around 7,500. But the Asiatic cheetah, this population is only found in Iran. They are very less in number, and they are also categorized as critically endangered. So they are already categorized as critically endangered species. Okay. So IUCN Red List status is vulnerable species. The Asiatic cheetah and the Northwest African cheetah are critically endangered. Okay. So India have cheetahs presence till 1948. Okay. Uh, India officially declared in the year 1950 cheetahs were extinct in India in the year 1952. So therefore, since then, India has been planning to introduce the cheetahs. India already made a formal request to Iran for Asiatic cheetahs, but Iran declined India's request. So therefore, India approached countries like Namibia and South Africa for cheetahs translocation program, and Namibia provided 8 cheetahs and India so far provided 12 cheetahs to India. So out of 20 cheetahs, 2 cheetahs were already died. Okay, and cheetah status is critically endangered. This is Asiatic cheetah. Okay, so cheetahs have lost 90% of their global habitat, and they now live in just 9% of the historic range. So compared to the earlier levels, they have lost almost 90% of the global habitat. So these are all the important and the relevant articles for both prelims and mains covered in the Hindu newspaper. Okay, thank you.